Supreme Court allowed one appeal in the matter of Pradeep Sharma versus State of Gujarat and another, and granted anticipatory bail while holding that the appellant, upon arrest, may be released upon furnishing a personal bond of rupees 1 lakh to the satisfaction of the investigating officer, and that the appellant will extend all cooperation during the investigation, and if investigating agency requires custodial investigation, it may apply to concerned magistrate for appropriate orders, and said application will be considered or decided on its own merits without being influenced by any observation made by the court. The facts giving rise to above both proceedings were that an FIR being ICR number 33 of 2011 was registered against appellants for offences under sections 409, 219 and 114 IPC at instance of respondent number 2 in appeal arising from SLP. The complainant was Mamlatdar of village Tankara at the relevant time and had lodged FIR on behalf of state, alleging that the government land bearing survey number 2 at measuring 65 acres situated at village Anantpara was allotted to one DJ Mehta and others on 19th May 1970 by way of Santhani for personal cultivation as per the entry made in the village form. Since the said allottees were not staying in the village and were not cultivating the land personally, the then Deputy Collector Morbi, registering the case as Sharatbhang number, forfeited the land in favor of the government. While order dated 15 November 2000, the said allottees in the year 2007 therefore filed appeal before then Collector Rajkot. In appeal, appellant as the collector set aside said order of Deputy Collector and directed to restore the land in names of said allottees. The said order passed by appellant was taken into revision by Principal Secretary of Revenue, Ahmedabad, who set aside order of appellant and directed to enter the name of government in revenue records. According to complainant, appellant, who was the district collector Rajkot at that time, had knowing fully well that the said allottees were staying abroad and not cultivating the land as per the order of allotment and therefore were not eligible to get back the land, set aside the order of deputy collector with a view to unduly favor them, and that too without verifying genuineness of power of attorney holder, who had filed the appeal before Principal Secretary Revenue on behalf of the legal heirs of the deceased allottees, Mr. Mehta and others. Thus, appellant acting against interest of government and with a view to unduly favor allottees had passed order with malicious intentions and thereby had committed offences under section 409, 219 and 114 of IPC. The submissions made on behalf of state of Gujarat in both the cases before High Court as well as the Supreme Court were the same. It had been submitted on behalf of state that appellant as a public servant misused his position by condoning an unjustified delay of 7 years in preferring appeal and passing an order that unduly favored the allottees despite their absence from India for over 2 decades. The order in question was passed on 27 March 2008, even though appellant had already been transferred to Bhavnagar on 24 March 2008, raising concerns regarding its legitimacy. It was further contended that the appellant misappropriated government land in favor of private individuals, thereby committing criminal breach of trust under Section 405 of IPC. Additionally, it was pointed out that two of the allottees were deceased and their power of attorney holder had filed false verifications on their behalf, which appellant ignored while passing the order. It had been argued that order dated 27 March was passed despite appellant's transfer. Deputy Collector had earlier cancelled allotment of land after finding allottees were not cultivating land and were residing abroad. Said cancellation order was challenged after 7 years, while setting it aside on ground of violation of natural justice. Appellant had also directed authorities to mutate the allottee's name in revenue records and hand over possession of land despite government already having taken possession of it. Reference was made to order of 2 September 2013 passed by High Court, which set aside subsequent decision of Special Secretary Revenue Department and remanded the matter to Deputy Collector for reconsideration. It was contended, despite setting aside Deputy Collector's orders for violating natural justice, appellant failed to remand matter back for fresh adjudication and instead directly issued directions for handing over possession. thereby exceeding his jurisdiction. It was further pointed out High Court had initially granted a stay on investigation against appellant within 20 days of FIR being registered. However, quashing petition was later rejected on 12 December 2018, and following this, investigation resumed. Thus, it would not be in interest of justice to quash FIR or grant anticipatory bail to appellant at that stage. Additionally, it was submitted that appellant had multiple antecedents with at least 10 FIRs registered against him, including one in CID crimes Rajkot zone concerning the alleged illegal allotment of 150 acres of government land. The state argued that given the nature of allegations and appellant's involvement in multiple similar cases, custodial interrogation was necessary and prayer for quashing of FIR or anticipatory bail should not be entertained. The pair seeking quashing of FIR and criminal proceedings is refused as allegations against applicant involve serious allegation of misuse of official position, criminal breach of trust, and alleged corrupt practices in discharge of public duties. The case against the applicant pertains to his passing an order that allegedly favored private relatives despite their long absence from the country and despite his own transfer from concerned jurisdiction. The contentions raised by state, particularly regarding lack of jurisdiction of applicant at time of passing impugned order, the alleged collusion in disregarding legal status of land and purported misrepresentation involving deceased appellants all indicate that method requires further and thorough investigation. Scope of allowing a prayer for quashing is limited and is to be exercised only in exceptional cases where it is manifestly clear that no offense is made of. However, in present case, FIR and materials relied upon by prosecution prima facie disclose commission of cognizable offences warranting full-fledged investigation. Moreover, the allegations against appellate cannot be adjudicated merely based on pleadings and require scrutiny of official records and procedural compliance. At stage of investigation, courts should refrain from preemptively quashing criminal proceedings unless there is evident abuse of process. Since the appellant's contentions relate to factual disputes that need verification through proper investigatory mechanisms, it would be inappropriate for court to exercise inherent powers to quash proceedings at this stage. However, considering nature of allegations and facts that matter is to be investigated primarily based on documentary evidence, the court was inclined to grant relief of anticipatory bail to appellant. Offences alleged pertain to exercise of administrative discretion in passing of order rather than physical involvement of overt criminal act requiring custodial interrogation. The prosecution had not demonstrated any necessity for custodial interrogation of appellant beyond scrutiny of official records, which can be done without placing him in detention. Additionally, appellant had expressed his willingness to cooperate with the investigation, and no material had been placed before court to suggest that he has evaded or obstructed investigation in any manner. Furthermore, it is well settled that anticipatory bail can be granted where custodial interrogation is not essential, particularly in cases where allegations hinge on official records, as presence of accused can be secured without pre-trial detention. Court also took notice of fact that FIR in question was part of series of similar allegations against appellant and in absence of any concrete material indicating likelihood of tampering with evidence or influencing witnesses, the grant of anticipatory bail is justified. Accordingly, while the appellant shall cooperate with the investigation as and when required, he shall not be taken in custody subject to conditions imposed hereinafter to ensure his participation in inquiry process. In light of observations above, we do not find, Supreme Court said, any merit in the appeal warranting interference with impugned order passed by High Court declining to quash the FIR in question registered with Ankara Police Station Rajkot. Accordingly, the appeal was dismissed.